Good afternoon, folks. Today is whatever the date is, and we are here in the Ways and Means Committee room. It's April 8th. We're just gonna spend about an hour plus together here this afternoon. And then we will be released. I think we worked enough hours last week. We can have some slightly shorter afternoons this week. And so we are going to hear about S51 from Senator Hardy, who is the reporter of the bill from the Senate. And then we're going to hear about S3. S51 is a fairly large bill. We're going to spend a great deal of time on it, likely. This is not something we're voting on today, but S3 is warned for a possible vote. And we have very little jurisdiction over that one. Senator Hardy, floor is yours.
Thank you, Madam Chair. Thanks for having me. It's nice to be here sitting at the table with you today. I've been spending time hanging out over there. For some of you know that, but listening to your conversations about education finance. But today, I'm here to talk about S51, which is an unpaid caregiver tax credit bill. And the background on this is a couple things. One, I spent 4 years serving on the Health and Welfare Committee and heard a lot of testimony from people who are caring for family members of one, dealing with one thing or another. A particular impact was a lot of the testimony I heard from people who have a family member who has Alzheimer's or dementia, and the just amount of time that family members spend taking care of other people, whether it's a spouse or a parent or perhaps an adult child with disabilities. There are a lot of family members who are taking care of other family members for a great sacrifice to themselves, both financial sacrifice. A lot of people have to leave their jobs or cut back on their hours or use their sick time in order to care for loved ones. Or they just leave their job. And then also just the emotional and physical toll it takes on people to care for other people, often leading to health problems of their own. So it's something that's been striking to me. And I think probably everybody in this room has been an unpaid caregiver at one point or another with somebody in their life. So it's something that has been brewing in my mind for a couple of years. We've also in this building multiple times tried to pass a very comprehensive paid family leave bill. I know the chair has spent numerous years of her life trying to deal with that. And this is not that, let me be clear, it's not that at all, but it is a way to get at it a little bit through a tax credit for, helping people at least make ends meet a little bit, who are doing unpaid care and not getting compensated for it. And then I teach a class sometimes in the off session at Middlebury College. And my students introduce bills of their own. And we do a mock Senate session. And one of my students actually introduced a bill last semester that would do an unpaid caregiver tax credit. And I was like, that's a really good idea. And she wrote the findings in the bill, and she testified down in the Finance Committee. So if you want her to testify up here on the bill, I'm sure she would be thrilled to do so. So the bill would provide a $1,000 tax credit for unpaid caregivers who provide at least 20 hours of unpaid care per week. It would be prorated based on the number of months per year, and it would be scaled in the same way that the child tax credit is scaled, which is something that this committee worked on at length a couple of years ago. So it's really modeled after the child tax credit in the way that the tax credit itself works. And it also, most unpaid caregivers, sort of universally based on the national data, are actually women over the age of 55. So this really gets a population of Vermonters who wouldn't be covered by the child tax credit because they tend to be older women. They also coincidentally, or maybe not coincidentally, are also the population that's most likely to live in poverty. And it's large part because of their caregiving duties and the finances that they've given up to be caregivers. So this is just a means of small compensation to help them make ends meet. I just want to give a huge shout out to Patrick Titterton, who you'll hear from JFO. He spent hours and hours working on trying to nail down a number for this. How many unpaid caregivers are there? Who would qualify? He worked closely with Dale, the Department of Aging and Independent Living, to try to figure out how many people it would work for, and then to help me and working with also the tax department come up with a sort of self-certification for that process too. So he can talk more about the fiscal estimate, whether there is one, it's a bill, and how he arrived at that. But in a year when I think a lot of us are thinking about taxes and how do we help Vermonters be able to afford to live in our state, this was one idea of trying to really help category, sort of population of Vermonters who are doing a great service to people by caring for them and providing some tax relief for them. So that is the background, and Kirby and Patrick can talk about the details, but I'm happy to answer questions if anyone has any.
Any questions for Sandra Hardy? I appreciate the new angle at an old problem.
Yes. Yeah.
And I guess sort of how do you think about the caregiver universe here?
So the caregiver universe partly is based on number of hours of care. So it's not somebody who just does a couple hours here and there. It's really sort of more of a dedicated caregiver of 20 hours per week. And those hours could be overnight, by the way. So there are a lot of people who care for their relatives, throughout the evening and nighttime hours. They also have to meet a few criteria that are in the bill that are regarding the person they're caring for has to have a diagnosis that requires that they need care and that they need assistance with activities of daily living, or ADLs, which are actually a term that are used by social workers and doctors to determine the level of care somebody needs. So there is a measurement that's used to say, well, this person needs assistance with 5 ADLs, and that's about X number of hours a week. So there is some math to it. So it's there, and that's part of what Patrick was trying to determine with Dale. And ADLs are used to determine, for example, Choices for Care program, which is the Medicaid program for people for nursing homes or at-home care. So it's a measurable kind of way of determining the level of care somebody needs. It also is very clear that it's not for people whose relatives are in a nursing facility or some kind of assisted living facility. Those people are getting cared for by somebody who's getting paid for it. So this is specifically for unpaid care. So that's how we are thinking about the universe. And it is sort of statistically most likely to be women over the age of 55. But one of my colleagues in the Senate asked me, what if it's a young man caring for his mom or something? And of course, if they meet the other criteria, there's no gender requirement in it. It's just that that's the population statistically most likely.
And I have one more question.
Yeah.
It is both a large tax credit in that it costs the state a significant amount of money, but it is also not a large tax credit in terms of the amount of money the amount of credit it is for each person.
Yeah.
What kind of impact do you imagine it will have on someone's life? I'm feeling, I sort of feelings about tax credits are just for like good vibes purposes,
Yeah.
respect purposes. And
Yeah.
it's like, I want it to make a measurable impact on someone's life if they're receiving it.
Totally fair. As introduced, it was actually $2,500 tax credit. So it was much bigger in terms of the impact on the state budget. The $1,000 tax credit, I think it would be similar to the child tax credit. It certainly wouldn't cover the expenses of having a child or caring for a relative. But there is, evidence that people spend a lot of their own money for care, and then they also need money to care for themselves. So maybe that it would help them do that more. But to really answer your question, I think you should ask people who are unpaid caregivers or the organizations that represent people who are unpaid caregivers to really get a sense of what the impact is on them and would it be helpful. based on the feedback I've heard and the testimony I've heard, it would be helpful. Sort of the every little bit helps category. It certainly wouldn't fully compensate them or pay their mortgage or anything like that. But, and also just one more piece of context. This is an idea that it's not entirely mine or my students' idea. There are bills like this in other states as well, and actually a federal bill as well that's called the Credit for Care bill. And it's a bipartisan federal bill that was introduced last year. I don't know if it's been reintroduced in this current Congress, but the first state to pass something like this was Oklahoma. And other states do it slightly different. They do it on a reimbursement case, but it actually becomes really, really complicated to reimburse expenses, and also sort of privileges people who can do that, and itemizing and all that stuff. So this is just a straight credit, but it sort of gets at the fact that people who are caregivers have expenses. And so at the very least, this credit could help pay for some of those expenses.
Thank you.
Yeah.
Thank you, Senator Hardy. Really appreciate you being here with us.
You're welcome. Thank you for taking up the bill. I appreciate you looking at it. I know it's a tough year, so thank you. And thanks for all your work. I've been watching and it's been fun. You're doing a good job.
Thanks. Please remember that when you are sitting with it in your own.
I will. Thank you.
Spread the word. Kirby, you want to join us? Thanks.
Good afternoon, everyone. Kirby Keaton, Legislative Counsel. I have 51 to share with you. So there are 3 sections to the bill and a 4th section for effective dates. The first section is findings, which are the type of findings that kind of make the case for the need. I take it you would like me to go through all of it?
No.
Okay. So
If you have to run somewhere, you could go faster and we could revisit some of it at a later point. We're not voting.
okay. Okay, yeah, I think we can aim to get through here. So section 1, findings, the general.
It's only 4 pages. I didn't realize that.
Right.
Okay.
General Assembly finds, first finding is according to the U.S. Department of Labor, women in the United States 55 years of age and older provide 26.6 million hours of unpaid care to family and friends daily. Number 2, according to AARP, more than 75% of family caregivers 50 years of age and older who retire early because of family caregiving responsibilities would have remained in the workforce longer if they had access to financial or non-financial supports. And if family caregivers aged 50 years of age and older have access to support in the workplace, U.S. GDP would grow by an additional 1.7 trillion or 5.5% in 2030. Third, according to a 2023 report by Urban Institute entitled Lifetime Employment-Related Costs to Women of Providing Family Care, the employment-related costs for mothers of providing unpaid care to minor children and parents-in-law and spouses, including unmarried partners with care needs, averages $295,000 over a lifetime. And the last finding, using a national survey and 6 focus groups, the Commonwealth Fund identified financial compensation for the time spent caregiving as a top policy priority for family caregivers. The next section of S51 is a statutory purpose section because tax expenditures require a statutory purpose under Vermont law. And the statutory purpose for this would be to provide financial support to Vermonters who spend significant time providing uncompensated care for a family member. Okay, so let's talk about the parts of this tax credit. It's available to a resident individual or part-year resident individual who provides uncompensated care. It's a refundable credit, which means in the case of the credit exceeding the tax debt owed, that there would be a refund for the person. The maximum credit, as mentioned before, is $1,000 for providing 12 months of uncompensated care per year One important component of this is that it is prorated by the month. It's each month spent providing 20 hours per week of uncompensated care for an individual. Of course, just like so many other income tax credits, it will be claimed by the individual when they're filing taxes. And then there are some requirements for the individual who is receiving care in order to claim the credit. So the first requirement is that the person receiving care must be related by blood, civil marriage, or adoption. Second, that the person needs assistance with activities of daily living, which is a kind of a medical term of art, not as a specific meaning. Home health care or assistance remaining safe at home. Third, has a medically diagnosed disability or health condition. And fourth, does not reside in any kind of retirement home. And then we get into the phase out for the credit. It does have a phase out, so it's means tested. Once the individual claiming the credits income exceeds 125,000 in AGI, it starts to phase out at $20 per thousands of dollars that exceeds that 125. And it's written so that filers follow that same phase out. Subsection C here is just the attestation that would be on the income tax return. And then subsection D deals with compliance. It says that the Commissioner of Taxes may ask an individual claiming a credit under the section to provide supporting documentation or other information relating to the individual's qualification for the credit. And then this next part was something that was added in the Senate after introduction, including a form prepared by the commissioner to be executed by a licensed medical professional, attesting that the licensed medical professional provides primary or specialized medical care for the individual receiving uncompensated care, and the individual has a medical diagnosis requiring assistance with activities of daily living for at least 20 hours per week. The individual claiming the credit shall have the form executed ahead of time before they claim the credit. And they're supposed to keep it for 3 years because that lines up with the audit period that the Department of Taxes uses for audits, or that the law allows them to use for audits. And it would apply to tax filing next year if it were passed. Those are, yeah, it's retroactive to 2025. The way it's written.
Oh.
That's partly on me. I've been doing that with a lot of income. I checked in with the Department of Taxes to see what they told me was, this is unofficial probably, but depends on how big of a lift it is.
Yeah.
And adding like one credit is not as big of a lift as what other things could be. So retroactive is fine.
Kirby, is this section D about upon the commissioner's request mean that you wouldn't necessarily have to provide this documentation? Or you just need to be prepared to provide it?
You need to be prepared to provide it. I'm imagining, like, since this is something that's going to be signed in a doctor's office a lot of the time, and most people filing their income taxes electronically, it's a little bit of an administrative issue with having it provided at the same time as income tax filing. Maybe that's surmountable. Maybe they're scanning. It just seems like it starts to become a problem. And also, when it comes to all taxes, it's up to the Department of Taxes to decide where are we going to get our biggest bang for our buck for auditing. So if the department decides this is worth looking into, they can go and get the form. But it wouldn't require the taxpayer to have to do some scanning or whatever on the front end. I think that's kind of the idea there.
Learn more about the group who are the recipients, the caregivers. What do they look like?
Well, it's anyone who is providing at least 20 hours per week of care for a family member, someone who's related by either blood or marriage or adoption. They can't be compensated anyway for that care. So they're doing it entirely voluntarily. And then that person, there's some requirements here for what that person has to need. It can't be just, for instance, it couldn't be just your child. If your child doesn't have a medical diagnosis like this, and need assistance with daily living,
But if he did, would he qualify?
they could, yes.
And does the caregiver have to be 55? Where did I see that?
No, it's just a lot of the findings do not completely overlap with what this credit does. The findings are kind of setting the stage for the problem, but there's a few things mentioned in the findings that are not specifically this group. Typically, the findings are talking about the larger group of uncompensated care that exists. But this credit is narrowed down beyond that, partly to keep the cost down.
Okay, so this handicapped child, could it be the mother who cares for him?
Yes,
Could it be the grandmother who cares for him?
yes,
Aunt?
yes.
But if the child was not handicapped, they wouldn't get anything. They wouldn't get a compensation.
That's true.
Is that legal?
Not for me.
That's a medical diagnosis.
I know it's not for babysitting, but these are children who still need care. And I bet a doctor would sign off that the 6-month-old needs to not be alone.
So the form specifically, and the form specifically states that the medical professional, doesn't have to be a doctor necessarily, has to sign off that the person requires assistance with activities of daily living taking up at least 20 hours per week. So it's not just any diagnosis. It's one that where the medical professional feels comfortable saying, this person needs like direct care for 20 hours.
I don't think being alive,
Because of the What's that?
I don't think being alive, even if you're 3 months old, is a medical diagnosis, you know?
I'm just wondering if, I know, I understand that, but I think this is discriminating
Maybe.
against that younger group.
One thing I would point out, which I didn't notice until today when I was looking over this, but when we added in the Senate, the form, and now the forms calls out activities of daily living, I think it would be cleaner to have that match the requirement above. Because there is a requirement for activities of daily living, but that requirement includes 2 other things as well. So to have the form match that requirement,
So activities of
a lot
daily
better.
living, that's taking a bath and feeding. And what else would that be?
the activities of daily living would have to have a nexus with the medical diagnosis.
And is that a term of art, activities of daily
It
living?
is.
The insurance companies use it. Yeah.
It's, and Department of Aging and Independent Living uses it.
Are you a lawyer?
Yes.
Okay, so doesn't this discriminate against children who are not handicapped and children who are young?
I would say just starting right off, this is a tax credit that a person may choose to claim. It's a benefit that they're asking for that they don't have to claim. So that already does not offer a good case for discrimination. And then the government and the tax code discriminate between groups all the time. It's whether it's an allowable kind.
Don't you love it how government?
I mean, but just the word discriminate by itself is not necessarily a bad thing. It's just saying we're going to treat you differently than these other people. That's all. And sometimes that makes sense.
I don't know. I guess I'm just sensitive because, I mean, nowadays it's so out of fashion to be caring for your own child 24 hours a day. And I think this is a good example of how everybody else in the world would qualify, but not the stay-at-home mother.
Well, we do have the child tax credit and the child and dependent care credit. And so I'm curious how this lines up with the dependent care
Yeah.
side of the child independent care, but. And maybe that's more a question for, I mean, I'm curious about that from a legal perspective and then also the
Yeah.
math.
I would wanna, and I thought about that too, but at this moment, I would wanna go back and look at what universe that covers as well. I think it's, it's stuff like paying for childcare, but it's more than that.
Thank you. Representative.
Thank you. Can you scroll to where it says, compensation? I can't have had compensation.
So part of the lead-in requires uncompensated care. Is this what you mean?
Yeah. Okay, so uncompensated, do they mean that you would have to, if you were being compensated, it would show up on your tax return? You would have income from there.
There could be.
Yeah.
There could be some way to tell if a person was receiving compensation for it. And
What about gift? Or if the person's getting paid for that?
that's the sort of thing that Department of Taxes has to sort out for things like this. If there is some proof that one of the individuals paid the other, and there's a question about was that compensation for the care, and the taxpayer would try to claim, no, it was a gift. Is that what you're saying?
Yeah.
Then that would be something for the department to get to the bottom of. There's certain things about this that can be checked for compliance. Like, are the people related?
Yeah.
The form from the medical professional. There's certain things about this that are going to be a lot harder to find out. And uncompensated care is one of them, one of the biggest, most obvious ones, at least 20 hours per week. That will be attested, and there's not going to be a way to know if that's true. And it's going to be subjective from person to person what they consider uncompensated care to count towards that 20 hours.
I guess I wanted to know if we had to, I want to ask generally the question then, do we have to define what compensated care is?
I mean, it does not attempt to define that. That is just the plain language is you provide care and you're not paid.
Okay. Plain language.
And then one thing to look into, and you don't need to answer this now, I believe that Dale has like a stipend type program already for certain folks who qualify and are providing caregiving within their home to their family members.
I think so too, for elderly.
Yeah,
Yeah.
or disabled folks, I think, folks with disabilities. So that's something that I would love to look at the alignment with that eligibility as well. If
Okay.
we continue this.
Yeah.
We'll hear from Dale, of course. Thanks, Kirby. Have fun downstairs. It was great to talk to you about something new.
And I like the bill. I like the bill because it is a gesture toward people who for generations have been just kind of not even thought of. Oh yeah, Aunt Millie's living at home taking care of grandma now. And you just kind of take Aunt Millie for granted. But it's a valuable service that's being somehow thought of as having value now. $1,000 is just a gesture, really, but it's something. It's more than she got the year before. It's putting up a price or a value on her skill. I think that's really good.
Okay, I'm gonna head to House Brooks.
Been a while since you've joined us. Nice to see you.
Nice to be in person.
Good.
Not coffee at you over Zoom.
Oh, that feels like 12 years ago, Pat.
I think it's like 2 weeks ago.
So much has happened in those 2
I
years.
know.
2
No
weeks
kidding.
ago.
I wasn't here though.
Oh. No, and my dad is actually very sick. I've been wondering, I got to the bottom of it. He has been scolded.
Patrick Chickerton, did I say that already? My fiscal office. I'm going to share with you the fiscal note. Can you all see that?
Yes.
Great. So Kirby basically just ran through all of the legalese around this, but just to sort of reiterate, because who doesn't love that? So the credit is refundable. The value is $1,000 if you qualify for the full amount. The income ranges of this are the same as what's in place for the child tax credit. So up to 125,000, you get the full amount. Beyond that, it phases out over the next 50,000 in income. And I'll talk about this a little more, but the dollar figure we put on this for fiscal year 26 would be $6 million. So it's there's just I'll run through some like caveats to that number a little later on, but $6 million, probably expect that to maybe grow over time, just because, we've had the demographics conversation, the state is an aging one. Well, a lot of people sort of developing disabilities as they get older, right? That require assistance, either paid or unpaid, right? So there's a few big sort of thresholds that you need to meet, sort of the number one being that the hourly amount of care that you need to provide every single week is 20. So over the course of the month, you would have to reach that 20 hours a week of care for that month to qualify. So if you only do qualify for 3 months out of the year, your prorated amount would be basically, 3/12 of 1,000, right? And 20 hours is it's a significant time investment to be putting in every week, right? So we do sort of view that as somewhat substantial hurdle or a high bar for qualification. Like Kirby mentioned, you have to be related, or the person receiving the care has to be related to the caregiver by blood, civil marriage, or adoption. They need assistance with daily activities of living, home health care, assistance staying safe at home. And they have to have the medically diagnosed disability or health condition. That's that form from the medical provider. And then basically they have to reside at home. It can't be in one of these assisted living facilities or nursing home. So it's sort of geared more towards the people who are, just trying to keep people in their homes. This language here references the phase out information and the full credit eligibility, but just to give you sort of a sense of what this income threshold captures, about 79% of Vermont tax returns fall below that $125,000 threshold for the full credit amount. And then a further 10 sort of sit within that phase out range, that 125 to 175,000. So all things considered, just based on income alone, not any of the other qualifications, this would cover approximately 89% of Vermont resident tax returns. So the majority, almost everyone. And so I think with those.
Can folks who don't live full-time in the state qualify?
If they are receiving care, that's a good Kirby question.
Okay, thanks. I just remember that being a big part of the
Yeah.
tax credit calculation journey. And so let's just put that on the burner.
Well, what comes to mind is I'm thinking of, cross-border situation where someone's mom lives in Massachusetts and they're 15 minutes away, but in Vermont, I don't know how that sort of shakes out.
It says part-time resident tax.
It says what?
It says
does
part-time
it?
resident in the bill.
Thank you for reading carefully.
But I'm unsure if that refers to the caregiver, the person providing care or
It
receiving it.
provides
It provides it.
uncompensated
Okay,
care.
thank you. So yeah, like Kirby mentioned, this is effective retroactive to this tax year. So this would start showing up in next April when tax returns start filing in. And then a couple of things I wanted to talk about with regards to the dollar figure next to the estimate. To get here, I use the phrase, I had to triangulate some surveys from different places to get to this number, because this is a population, while the iteration of this population in the bill is not something that's expressly tracked, at the federal level or sort of specifically in the many, caregiving surveys that I came across when I was looking into this. So, right off the bat, so one of the hopes and sort of assumptions that's being used here is that certain statistical results in different surveys are reasonably, true about the general population as a whole. There's information from AARP, there's some Alzheimer's Association survey information that was referenced. I did talk to Dale in respect to their Choices for Care program. So there is sort of an underlying assumption that some of these different surveys can sort of speak to each other and sort of more broadly describe the population. With respect to the self-attestation for the number of hours, I don't know that anyone is specifically tracking how many hours of care they're providing on a weekly basis. They probably can estimate it for you. When there's a financial incentive, I'm not suggesting anyone would do this maliciously, but when there's a financial incentive to maybe round up a little or say that you maybe did a little more than you did, that's something that could affect the estimated number here, because it is self-attestation. It's not being explicitly tracked anywhere. And then kind of to the conversation about children, one thing that kind of arose is that, so children, for example, they need assistance with daily activities that aren't related to any sort of medical condition, right? So when you're feeding someone, if you need to clothe them, transport them, that's providing care for maybe some essential things that they need, but that might not be explicitly related to what their medical condition is, right? So the assumption again here is that all reported hours that a person is saying they provided care for someone is directly related to things they need because of the medical diagnosis or disability. So I think just those three things I want to sort of point out there, just to let you know that there are some areas from our office's perspective where our number that we have here is there's some uncertainties. People always ask me, like, can we estimate this? Can we estimate that? And the truth is we can estimate anything. But, there's always varying levels of confidence with it. So I just want to sort of highlight that.
I know you tend to estimate upwards on lost revenue so that we can be safe to make sure that we will have because that's the conservative, fiscally responsible thing to do. In this case, I guess I'm wondering what is your band of.
I don't know if I'd feel comfortable giving a band.
Okay, it's a pretty wide band.
Well, because there's a couple of things in my mind that kind of roll around. One is it's brand new. It's somewhat, some of these forms that you have to get done do create some hurdles to claiming the credit. So uptake for, 100% of the eligible population might not be there in the first year or two, just as people sort of learn to navigate it. But on the other hand, just as an example, like I mentioned with the attestation, there could be some uncertainty in there as well. And then again, the third piece, which is just this is comprised from several different surveys, and if the assumption that they don't sort of mesh well with each other, they might not be sort of appropriately representing the people who would be claiming the credit.
And on that, do you have any idea of the overlap with the dependent part of the child independent care credits?
In terms of who's claiming, or?
Yeah, if we would have lots of people claiming both.
You certainly could be. And I want to answer one other thing that came up that's not related to this in a second. You certainly could be, because, there's the time spent where you have the out-of-pocket expenses to pay someone else to provide the care. But then, if it's a child living with you, or if you're going and staying with a parent for the time that they're not having that paid care given to them, that's where we fall into this bucket, whereas the other one is sort of reimbursing expenses. And that's sort of like a philosophical difference between the two. One being a direct reimbursement for expenses out of your pocket, whereas this is more of a compensation for time not spent working, because you're unable to, because you have to spend the time to provide the care for someone. And the one thing that you had actually referenced within the Assisted Care program, there is a program called ARIS, I think it's called, which is run through Medicaid, where you can actually set up like a payroll service and put a family member or someone on payroll through that program. And so I think that is the program.
Yeah, it's like less than minimum wage, I think, too,
It's
somehow.
whatever the rates that they set are. But even in that context, if you're being paid through a program like that for 15 hours in a week, but there's a further 20 hours you're completing outside of what you're being compensated for, you're still eligible for this, as long as you hit the 20 hours uncompensated.
Last question.
Okay. I'll try to.
No, it's yours. Go for it. You don't.
Well, I'm still having trouble with this because it seems to me that the opposition is not seeing the value, the humanity, the care that these people deserve, whether or not they're handicapped or whether or not they're school age or not. It just seems like that there's something that's really not right about our society that doesn't value that extension of kindness, of, care that these people ought to have simply because they are human. It doesn't matter if they're handicapped or 2 years old. It doesn't matter what reason they need care, in my mind. If they need care, it's because they are people, and we ought to care for them, everybody, no matter what their condition is. And I don't mean to keep looking at you. I don't know how better to explain that, but to me, it's a thing that comes from being part of a society that gives more than it takes. And we're not doing that here with this bill by segregating out part of our population. Even by saying, I know he said this was in the findings and not that it would be women over 55 who would collect this. That was in the findings, wasn't it? So it wasn't part of the group eligible to get the money. Okay, forget that then. But my first part of my statement holds. I just think there's something that in my mind is worth raising the issue, even if it's a big brawl on the floor. I think it would say something about us if we bring this forward and include everyone who's needy and not just those who are medically handicapped in a way. Because you know what? If you have children, a 6-month-old baby is handicapped. He can't feed himself. He can't live unless there's someone with him all the time. Has to be, or he won't make it.
Thank you, Representative Brannigan. I think that's a really helpful segue to, thank you, Pat. And I mean this as a helpful segue. So we have a number of tax credits that did not get out of our body before crossover that are still in our jurisdiction. And we have this one in the mix now too. And so we are going to spend some time before the session ends, figuring out how all those talk to each other and what we're going to do about it.
I love it.
Yes, sure. And so if folks want more testimony on this, please give it some thought. Dale, of course. And I imagine there's some other folks who would want to testify too. So give it some thought, let me know. And with that, we're going to totally switch gears. Eric, if you want to join us. We usually share screens here, but
Yeah.
do you have the Zoom link by any chance?
Pardon me?
Do you have the Zoom link by any chance from Source Sheets?
I do. I think I can pull that up, or I can just share my screen. Oh, I see. I probably have to join the meeting, right?
Yes, you do.
Right.
So folks, we really have no jurisdiction over this bill at all. Sometimes trusts, and I'm going to explain why it's here. Sometimes trusts are essentially used as tax shelters. I think we all know that. And so all trusts now come here because sometimes they're tax shelters, and so they matter to us. My understanding is this trust is in no way related to being a tax shelter, but it's here anyway. And so we're ideally going to spend a very brief amount of time on it and vote it on its way and move on with our lives. But who knows what will happen?
Sorry, Eric Fitzpatrick with the Office of Legislative Counsel, as the chair said. I'm just sort of signing in real quick here, trying to do this simultaneously. So that I can put the text up on the screen as I do. And while I'm doing that, I'll try and simultaneously talk a little bit.
You don't have to multitask if you don't want to.
It's sort of a nice challenge. I could try, but I'll just get, I'm sure I'll get mixed up. I wonder about the volume. Oh, there we go. So I'm gonna share my.
I think you got it.
Am I good?
I think so. And Saoirse, you're good if I go? I'm gonna take that as a yes. I saw you unmute and then mute. Oh, I did not make you a co-host.
Did I go back a little bit?
No, it's not you, Eric. Saoirse, did I mess it all up?
He's a co-host.
Great. Okay. Eric, before you leave, can you make Saoirse a co-host? Or Saoirse, are you a co-host now?
I'm the host of the meeting. I'm all
Great.
set.
Okay, thank you. Back to you, Eric.
Getting there.
Success.
Success. All right. Good afternoon again. Eric Fitzpatrick, Office of Legislative Counsel, here to talk to the committee about S3 and act relating to the transfer of property to a trust. If anybody has had a chance to look at the language of this bill, you probably notice that there's a lot of legalese there, a lot of highly specific language toward trusts and property law and that sort of thing. So I think it might be helpful to talk for a minute or two about the background of what's going on in this bill before jumping into the text and getting maybe lost in the weeds, which is what happens to me when I start trying to look at that language right away without a little bit of grounding as to what's going on. So what's going on here is sort of the intersection of two areas of law. There's trust law, as the chair mentioned, and there's also property law. So quick 10 seconds, refreshing your recollection about the trust situation. Remember, there's three parties in a trust. There's the settlor, who's the person who puts the property into the trust. So someone owns property and says, I'd like to set up a trust, and the person who puts the property in is known as the settlor. The trustee is the person who manages the property, who comes into the trust. They decide who's going to get the, of course, has to go along with the terms of the trust, but they follow the terms of the trust. They have a fiduciary obligation to the property in the trust, and they can distribute the trust proceeds to the third party, who's known as the beneficiary. So you have the settlor, the trustee, the beneficiary. One important point about the trustee for purposes of this discussion is that when the property goes into the trustee becomes the legal owner of the property. They have a fiduciary obligation to how they manage it, but they are the legal owner. So they're distributing benefits to the beneficiary, and also the beneficiary and the settlor can be the same person. So the settlor can put the property in there and also be someone who gets the benefits from it. But keep that in the back of your mind that the trustee is technically the legal owner of the property, because that's important for what's going on in this bill. So that's the trust. Set that aside for a second. Let's go to property. Now, property law, this has to do with joint ownership of property. So more than one person can own property. And there's different legal statuses that joint ownership can have. And this deals with a particular type of joint ownership that's known as tenancy by the entirety. That is reserved for married people who are spouses. Now, there are other types of joint ownership. There's, for example, the three main ones. There's tenants in common. More than one person can own property as tenants in the common. Anybody can do it. If you own that, you own your own share, specifically your own share, like, and if one person dies, for example, so say I was a person, then my share would go to my heirs, you know, if I kids, if I had any, my brother, my sister, whoever it might be. Second type of joint ownership, not involved in this bill, but it's helpful to understand what's going on. Joint tenants, it's called. That is what's known as, also anybody can do it. I can do it with my friend, my spouse, my family member. We can all own it. Joint tenants joint tenants. That has what's known as right of survivorship, though. Different than tenants in common. That means if I die, my share doesn't go to my kids or my brothers or anything like that. It goes to the other tenants. So if there were two of us who decided we owned it that way, if I die first, my share goes to the other tenant. So my kids or somebody else not involved in that sort of situation. That brings us to this third type, tenancy by the entirety. Only spouses can have those. They are the only people who can own property in this fashion. That also has what I just described, the right of survivorship. So if one spouse dies, doesn't go to anybody particular from that spouse's line of inheritance, it goes to the other spouse automatically. Doesn't have to go through probate. It also has another particular feature, and this we're going to get into. This segues us into this bill, known as creditor protection, and it's only a tenancy by the entirety, which spouses can have, which has this creditor protection feature. And that means that, let's say two spouses own property and they have it as tenants by the entirety. The property is protected from the creditors of only one spouse. So for example, say one spouse goes out and signs up for a credit card in their own name without the knowledge of the other spouse. And it's not a joint account. It's one spouse's account. And let's say that spouse then defaults. Then the credit card company wants to come and collect on the debt. They can't collect on it and try and attach the property that the spouses own as tenants by the entirety. It has creditor protection. And the sort of legal reason for that is that the spouses are viewed as each owning an undivided 100% interest in the property. You don't own it 50-50. Each of them theoretically owns it 100%. So creditor can't come and say, hey, I want the 50% that this spouse had because they're the one who signed up for this credit card and they owe me this debt. Can't do it. It's creditor protection. In order to maintain this creditor protection feature, you have to continue to own the property. The spouses have to continue to own it as tenants by the entirety. All right. So let's say spouses, as they often do, decide when they're planning their estate and what they want to happen to their property when they die, they want to set up a trust. They say, okay, we want to put our house into a trust. And that way, one of the advantage to that, as you may recall, I think I've been in this committee talking about this particular topic sometimes, is that it doesn't have to go through probate, right? That if it's in trust, then, little quiz to what I said in the beginning, who owns the property when it's in trust? Trustee, exactly.
Oh, this is.
That's a good one. Excellent.
In the afternoon, very.
So true. But yes, the trustee owns the property. So that means it doesn't have to go through probate, right? Because the people who died didn't technically own it. The trustee did. However, what's the problem? If the if the spouses wanted to maintain their property as tenants by the entirety, they want to maintain that creditor protection feature, and they also want to put it into a trust for purposes of their estate and have it go right to their, the kids, their family, whoever it is they wanted it to go to when they pass away. Problem is that they don't own it anymore. It's the trustee who owns it. So the creditor protection feature is gone. If they want to do that, in other words, if they want to use a trust as their estate planning tool, as a way to have their house or whatever other property they have go to whoever they want it to go to directly without having it go through the time and expense of the probate court process, they could do that, but then they wouldn't have that creditor protection feature anymore because they don't own the property anymore as tenants by the entirety. The trustee owns it. Here you have the reason why a committee of the Vermont Bar Association met last year to try because they were coming up with situations where married couples wanted to put their property into a trust for purposes of estate planning, but then they would lose the standard tenants by the entirety protection feature, which has been part of owning property of tenants by the entirety for centuries. So that is why you have S3 in front of you. This study committee of, I think it was the probate section, the trust and estate section, and the real estate section of the Bar Association were meeting last year. And they came up with a way, as it turns out, I say they came up with it. There's about a dozen other states that have this as well. So they didn't invent it. Not that I'm trying to say that they weren't creative, but there are about 12 other states that have this. And it basically is a pretty straightforward, if we look at the language, all the language just says, if people own property as tenants by the entirety, married couple, in other words, if they own property as tenants by the entirety and they transfer it into a trust, then they retain the same, then the property retains the same creditor protection that it had before they transferred it into a trust. That's it. That's the legal effect of what it does. So it takes the creditor protection feature that it has now, that it would have under current law as married folks, and retains that if they decide they want to put it into a trust.
So they've got a trust now and they can change it to the not an irrevocable trust.
They could. That, interestingly, they wouldn't necessarily have to, because the bill actually has a retroactive feature. I'm sorry, I'm skipping ahead, but you segued me right into it, so thank you. Right down on, it's on page 3, down there it is on line 13 through 60. So this provides that, so let's say the married spouses had made this transfer of property into a trust 2 years ago, right? This provides that now, line 13, notwithstanding 1 VSA 214, you may recall that's the statute that generally provides that new laws only apply prospectively. But you can exempt from that. You can say, in particular situations, not unusual, we want something to apply retroactively. So that's what this proposes to do. Notwithstanding that, this subsection C applies to all trusts created before, see that line 14, before, on, or after the effective date of the subsection, and to property held by spouses as tenants by the entirety that is conveyed before, on, or after the effective date. So in other words, if it meets the criteria, which I kind of skipped over because it was a nice segue to this retroactivity piece, but if it meets the criteria, even if you did it 2 years ago, if the spouses owned it, if it was jointly owned property by the spouses, if they had it as tenants by the entirety and they put it into a trust, then it gets this creditor protection feature, even if they don't necessarily make any changes now. You don't have to do it. You might want to do it. They might want to do it just to be sure. They might want to have their estate planning attorney, if they have one, or look at their trust themselves just to make sure that that's what they did, but it wouldn't necessarily require any action.
And so I know we haven't gone through the bill language yet, and I'm happy for us to do that in a brief way.
Sure.
I just want to clarify that all this is doing is adding the creditor protection feature.
Exactly.
Okay, to existing future trusts.
Right.
Great. Folks, I'm gonna go. Bill's gonna chair. You're welcome to vote without me. Thank you, Eric.
Absolutely.
You want us to vote this out?
That would be delightful, but if you don't feel comfortable doing that, then no.
Representative Maslin.
Yeah, before we looked it out, Eric, is there a downside to this bill? I can't see one, but I wonder if there is.
Not sure that that's more of a policy question, but I can say that I didn't hear any testimony that I was voted unanimously out of both Senate Judiciary and House Judiciary. There were witnesses in, I didn't hear any testimony.
Goodenough right here if we have any
Right.
questions.
Right. I didn't hear any testimony to that.
Thank you.
Yeah.
In case you wish to sit in the chair, if it didn't hear anything
Well,
different.
wait a minute.
So,
The language we haven't gone over entirely. What's your pleasure? 3 pages.
I can be very quick if that's helpful.
I would
Yeah, no,
like
please,
that.
just-
I think we should-
All right.
Yes. Eric, please.
It's not hard.
All right. So because of the little background that we've gone through, I think I can go through this pretty quick. So subsection C1, first of all, it's helpful that it's being just added to an existing statute that already is part of the trust law, which already deals with creditors' claims against the settler. This is exactly similar to that subject, which is, hey, when can a creditor get at property that the settler has contributed to a trust? So, and this is saying, well, look, if, and this is I just described, if spouses own property as tenants by the entirety, and they contribute that property to a trust, that's what subpart lines 5 through 10 says, property held by spouses as tenants by the entirety, conveyed to the spouses jointly or separately, and any proceeds of the sale shall be immune, this is line 7 and 8, shall be immune from the claims of the spouse's separate creditors to the same extent as the property would have been that remained held by the spouses as tenants by the entirety. Everybody follow what that's saying? So that's saying that, it's going to have the creditor protection feature the same way when it's in the trust as it had before you transferred it to the trust, if the following apply. So you have to meet these criteria. Spouses have to be married to each other. That's A. The property is held in the trust or deeded out of the trust as tenants by the entirety. So it has to be held as tenants by the entirety. There's some revocation language in C that's just about what circumstances it can be revoked under. D, property is a spouse's property, so they have to own it together. It's not one spouse or the other, it's the spouse's plural property. And both spouses are either current beneficiaries or one spouse is a beneficiary of the trust as well. So it's not that they have to be the only beneficiary, but they have to be at least a beneficiary. So if those criteria are met, then the property that's transferred into the trust retains creditor protection the same way it had before they sent it. Make sense so far? All right, so that's how you get it into the creditor protection benefit by transferring it into the trust. Subdivision 2 says, all right, well, once it's in the trust, then what happens? All right, then it basically repeats what I just said. The first sentence, lines 1 through 5, property anytime held in a tenants by the entirety trust shall have the same immunity from the claims of a separate creditor of either settler as the property would have if it were held outside by the trust by the settlers as tenants by the entirety. So you get the same thing. Now, important caveat there. So this is a may, not a shall. Because you look at line 4, unless otherwise provided in writing by the settler or settlers who transferred the property to the trust. So in other words, if the settlers are transferring the property, in this case, it would be the married couple. If they don't want to do this, they don't have to. They can otherwise provide in writing. They can say, all right, we don't want this for this piece of property. We don't want the creditor protection feature to apply. So it's an optional thing. It's not mandatory. All right. The second sentence there says, all right, so that once the property's in there, it's treated in all respects as tenants by the entirety property. So same way it was treated before it was put in the trust, it's treated that way afterward. Subdivision B, lines 8 through 10, if the marriage is dissolved by a court, you don't have the creditor protection anymore. Same thing that would happen if there never wasn't a trust involved at all. If the two people who are married own property as tenants by the entirety, they get divorced, they don't have the protection anymore. Same thing if it's in a trust. The subdivision 3A, I already went over, there's a retroactivity piece. So even if married people had done this 2 years ago and they complied with all those 5 criteria that we looked at, then it would also get the creditor protection. Subdivision B is a prospective piece. If this subsection only applies to litigation, if the litigation, in other words, if a court case was started 2 years ago, this provision doesn't apply anymore. But if a court case is started, let's assume that it goes into effect on July 1st. After July 1st, then this applies. Prospectively for court proceedings. That's pretty much, I think that's it. Yep.
Representative Brannigan.
Do we know, wait a minute, what was that? It was one of the rules here. Number A. The spouses are married to each other. How do we know they're married?
I think that would be like a certificate of marriage, something like that.
You have to have a certificate.
I think in terms of being able to, if it were, for example, disputed, then yes, I think that's how you would demonstrate that the spouses were married.
What if it got burned up in a house fire?
Then I think the rules of evidence would permit other ways of proof.
See, aren't you glad we ran through the lines?
Just wondering. So,
Yes, bridesmaid.
Yep, witnesses could absolutely testify. Absolutely.
Tax return?
Tax returns, another good, yep. Yep, also would likely be admissible.
Hey, Representative Higley has a question. Raised his hand, Carol.
I hear you say in the beginning of your testimony here that it used to be this way, but somehow it isn't anymore, and that's why we need to correct it.
No, I think it was more a matter of it not being unambiguous in statute, so that some attorneys who are giving advice to their clients who are wanting to set up their estates, who are wanting to plan for when they pass away, aren't 100% clear that that's the way it is. I don't think that it's necessarily not been true, and I think some have assumed that this would be the case, and but for purposes of clarity, to put it on the books.
Thank you.
Representative Maslin?
As Mr. Chair started jumping on earlier, I wondered if Representative Goodenow heard anything different in this area, or is this all consistent?
Hello, Representative Goodnow from House Judiciary.
There for a second.
Your lowly bill reporter for SD as the one attorney on other attorney on Judiciary. I got the complicated bill. No, I think everything that was identified by Eric is kind of what we heard. We heard from the Vermont Bar Association, from bankers, and from Judge Zone, and everyone was in agreement that this made sense and that there wasn't really could be any issue.
Okay. Oh, Representative Coleman.
This is not actually part of your change, but I'm just curious why subdivision 2 does not apply to an irrevocable special needs trust. So it's line 15.
On the second
First
page.
page.
It's probably for Eric, not me, but.
And if you don't know, it doesn't matter because it's actually not part of your change. It doesn't.
Yeah, I'm not sure it's existing law, but I'm not sure what the reason is for exempting irrevocable trust to that particular creditor claim features. Because they can do it, but I'm not sure off the top of my head. But I can easily get an answer to you. That'd be helpful.
Sneaks away.
Mr. Chair, would you like a motion?
I would.
So I make a motion, we approve S3. It's currently law
As presented.
as presented.
Second, Mr. Chair.
No second needed.
Says-
I appreciate it. So you've heard the question. The clerk is ready.
Clerk is right.
The clerk, please call the roll.
Representative Brannigan.
Yes.
Representative Burkhart votes yes. Representative Feltus.
Yes.
Representative Higley.
Yes.
Representative Holcomb.
Yes.
Representative Kimball.
Yes.
Representative Maslin.
Yes.
Representative Odie.
Yes.
Representative Wazazak.
Yep.
Representative Canfield.
Yes.
And our fearless leader, Rep. Kornheiser, is not here. So we have voted the bill favorable 10-1, or 10-0-1, sorry. 10-0.
Representative Brannigan.
Mr. Chairman, I have two comments. First, it's snowing again.
It's that, it's when Higley came back.
And the second thing is, it's been a long time since we've had an afternoon to just have fun.
I know.
You know?
Yeah.
I mean, a long time.
So
So everybody's kind of letting their hair down.
what's that got to do with this bill?
It's a relax.
So, Representative Maslin.
Yeah, I think judiciary is one of my responsibilities for reporting on the floor, so I'm happy to report this very complicated.
Ah, that's nice that you offered that, but the chair, who is no longer here, requested Representative Canfield to.
Okay, that's fine.
Oh.
You want it?
I've had very little to do this year, so that's all, but if Emily.
A lot of the big ones.
Chair can have. The chair has reasons for doing what she does, and so she can make the call,
Yeah, okay.
of course.
So Canfield will report,
Okay.
and I hate, source is gonna send me the info I need to get to clerk's office.
Yes, I will.
Thank you. And you can take us off live, please.